Hi, I'm attorney Renee Osipov with Chelle Law, and we assist veterinarians with contract agreement issues. Today I'm answering the question, how many locations should a veterinarian's non-compete apply to? So let's first start with what is a non-compete. There's normally two components to a non-compete clause. It restricts you after your employment has terminated with your current practice. So you are restricted from providing, it's normally veterinary services, or if you're specialized, any of those specialty services for a period of time within a specific restricted area. Normally they're for 1 to 3 years. And then today what we're discussing is how many locations should that restricted area apply to. So normally the restricted area, it can really be anywhere from 1 mile all the way up to 20. It just really depends where you live in the United States. If you're in a city area, typically it's going to be less miles. If you're in a rural area, normally that restricted area is going to be larger. So we've got our time frame, we've got our restricted area, but now we need to know a very important question. How many locations from your practice is that restricted area attached to? So if you're a small practice and they only have one location, that's pretty easy to figure out. It's only going to attach to the one location that you're providing services for. It gets a little bit more complicated when there are multiple locations, multiple clinics, or if it's a corporate veterinary practice, which is very common nowadays. So if there are multiple locations owned by this practice, you have to be careful and read your non-compete clause very carefully. Sometimes there's language that states that you're restricted only from your primary location that you give services at, within 12 months of termination of that agreement. That's kind of like standard language. It gets a little bit trickier when there's language in the agreement that states any location that you provide services at. So why does this matter if it says any location? Well, if you fill in for a vet who's on vacation, boom, that non-compete restricted area now attaches. There's no sort of language in there that says, for how long you have to be giving services at that location. It just says any services, and you provide it, then boom, that location now has a restricted area around it from competing. So this can get really complicated if you move around and you're here or there, but you do have one primary location. Another sort of scenario that I see a lot with clients, this pertains more of the corporate practices. It will say, if it's corporation, ABC, let's just pretend that's the name of it. The non-compete clause will say that the restricted area attaches to any location owned by corporation ABC. So now this gets really complicated. So when you sign that document, the corporation may have 10 locations. So right off the bat, that's overly restrictive. But if they buy up 20 or 30 more practices within the United States or the state alone, now you have a huge area that you are restricted from practicing. Would this be enforceable? Depends on what state you're in, but it would definitely be unreasonable. And even if it would not be enforceable, you don't want to get into a situation where you have to litigate that and spend money paying attorneys to fight out the terms of your agreement that you signed. So to prevent all of this from happening, I always recommend read your agreement very carefully. When you get to the restrictive covenants, that's your non-compete clause would be included in there. Read it carefully and see what locations does the non-compete attach to. It really should only attach to your primary location. You really want to advocate and push for that because if it starts attaching to any place you provide services for, you need to be very careful if you decide to cover for a vet, knowing that now you are restricted from that area, from that location. And the other thing you really want to look for is if it's any practice or any location that the practice owns. You want to be really careful there because you actually don't even know what the future will hold for that corporation and how many practices they're going to buy up in the future. And so you could really be limiting yourself. So you definitely want to read your employment agreement carefully and look for language that's only restricting your primary location. Thanks.